the Tories brought in their 911 fee. And actually the member for Cape Breton West was here. Liberals, I think, were in this position in opposition where we're seated. And I think the member for Cape Breton West was the one who railed on the Minister of Health at the time, and what an injustice it was to bring in this 911 fee. And the Minister of Health stood up and said, "You guys signed it before you left." So how is it that people are to believe anything that the members from the Liberal caucus say in relation to this piece of legislation? Because I have to say, Madam Speaker, that when I hear members of the Liberal caucus rail about the injustice of workers' compensation on a piece of legislation, previous legislation that they put through this House, then I have to wonder why they didn't fix it in the first place. But they designed it, they wrote it, and they put it through this legislature, and it had a negative impact on the lives of people, which they had been told about and weren't willing to fix. And actually, one of the sad points of this legislation, even though the Supreme Court says you have to take care of those with chronic pain the same as you would anybody else, there's nothing really clear as to what level of care or compensation that they have to go to. And that's one thing I worry about. And also the fact that they're not bound to go beyond the date of that section of the Charter, 15.1, Section 15.1. When it came into effect in 1985, that's as far back as this legislation has to go. Now, it's not bad enough that we have to take the government kicking and screaming to do the right thing, but they'll still hold on to this, this legal claw that means that they don't have to go any further than the Charter says. And if yes, I think that anybody who was injured in this province, who is alive, should be compensated. That's how far I think we should go. But governments don't seem to recognize what compassion is. Matter of fact, they have to be told what to do and still don't recognize any compassion for that. So until the Supreme Court says they have to do it, they're not going to do it. And they should have done the right thing in the first place, even if they thought that they were covered under the Charter. So even with this Supreme Court decision, they still look for a loophole so that there were people out there who were injured workers who don't have to be taken care of under this legislation. So only back to 1985. And that's, and to the honourable member from Cape Breton West, Madam Speaker, no, I don't accept the question. I've gone down that road and I found he doesn't accept an answer. Now,
from Cape Breton West, on a point of order.
Yes, Madam Speaker, I'm completely perplexed as to what the honourable member is suggesting, and I've asked perhaps if you'd be kind enough, through this point of order, clarify. At the outset of his dissertation, he suggested we should be following the order of the Supreme Court of Canada, and now he's suggesting that we should go far beyond the limits of the order of the Supreme Court of Canada. Could he please be kind enough to give us some clear indication as to where he's going?
It's not a point of order.
Not even a good question.
Sorry. Back to the honourable member from Hants East.
Thank you, Madam Speaker, and to the honourable member. If it means to go, if compassion could go beyond the order of the court, then go beyond the order of the court. Now, Madam Speaker, I don't know if the problem we have in this province, or maybe in this country, but certainly in this province, if the problem is with the design of the workers' compensation program at all, which I suspect is part of it, because I don't think it really was designed to help injured workers at all. I think it was designed to give businesses a way out so they couldn't be sued by injured workers. I think that's what it was designed to do. It wasn't designed to actually take care and fairly compensate injured workers. There's just no evidence that that really has ever happened, as far as I can see. What I'd like to see is if resources, or if it's stinginess on parts of government is the problem, I'd like to see the province get back what it contributes to EI, disability, and combine that with workers' comp. Come up with a compensation program that actually takes care of injured workers. Because we certainly know there's billions in EI funds that working Nova Scotians have contributed to, and it's never come back to them to make any use of that, Mr. Speaker, or Madam Speaker. I'll get this right one of these times. And I think that has been an injustice on the part of the federal Liberals. When it comes to Atlantic Canada, they haven't shown a lot of fairness. So. But there has to be a mechanism that really looks out for injured workers. It has to be one that I think taxpayers will be satisfied with. And I think treating people fairly is something that the taxpayers can swallow. I think what they're tired of seeing is money go into places that that they've reaped no benefit from. Fly-by-night businesses that come and go and take taxpayers' money and not offer anything in return. I'd say take care of Nova Scotians first, Madam Speaker, and these are the people that I think, if there's any lesson to be learned, these are the ones who are committed to the province. These are the ones that get up every day to support the province, and these are the ones that the province should finally stand up and support them. This piece of legislation that the government is bringing in, I would really like to see the regulations in the legislation. As they say, the devil is in the details, and a member from Cape Breton West has made the point that all parties will be involved in at least seeing those regulations. I'm not sure how much input anybody's going to get into that, and I can just hear it afterwards. If the regulations are what I would expect them to be, not much, the government will be saying, well, the NDP and the Liberals were involved in drafting that. So that's a road I would just as soon not go down. I would say keep it open and transparent. Let's see the regulations in the legislation so we actually can know what there is about this bill that we're debating, Madam Speaker. There is some things here that good is only as good as what you're willing to do with it. The board shall hold an annual general meeting each year that's open to the public. Great. So the question is, what do they do with the information they get from the public? If there ever was an example in 1998 legislation on workers' compensation, I watched people in a lineup come to law amendments and tell their stories about being injured and the workers' compensation system, and I saw almost none of that go into the legislation. I saw nothing that really truly affected or improved the lives of injured workers. And so if they're going to have a public meeting with the idea they're going to try to tell me that, oh yeah, we're going to listen and we're going to change things because we're having a public meeting, I'll believe it when I see it. This is a way to say that we listen, but like I say, for the Tories or for the Liberals, your legislation clearly defines what it is that you want to do, And that's the message that we should be sending to Nova Scotians. You can't escape what you put in legislation. We've heard a lot of talk about the Dorsey report. It's not something that I am as familiar with as the critic for our caucus. At least one of the recommendations that the Dorsey report had stated that protection coverage to all excluded persons is at least something that we're seeing, but only because of the Supreme Court of Canada had made that ruling. And if governments actually want to avoid going to the courts, then write legislation that actually works for people. Take a look at what is written in the Charter, make sure that your legislation incorporates that, and that would limit the court cases. And I got to say, it's probably a master plan on part of the Liberals or the Tories, in the sense that who's going to court? You got people with no income. You got people with no income, Madam Speaker, who have to just make a decision about what compensation level they're going to accept if they get one. And in the case of chronic pain, people weren't going to get it, some of those people. And here they are, poverty-stricken, having to hire lawyers to fight the government. Now, I would say that's pretty masterful on the part of the government to say, well, people can sue us. Well, yeah, the fact that they're flat broke, destitute, would make it pretty darn difficult for anyone to take on the government. And when you've been beaten long enough, just to feel good enough to try it is an effort, Madam Speaker.
Order, please. Would the honourable member allow an introduction from the honourable member from Cape Breton North?
Yes, thank you, Madam Speaker, and thank you very much, Madam Speaker. I want to thank the honourable member for allowing me the opportunity to make an introduction at this time. Madam Speaker, in your gallery this afternoon, we're joined by a Sydney area businessman, but more importantly, Madam Speaker, has been my campaign manager the last two elections that I've run. And I'd like to ask all members of the House to join with me in welcoming Kirk McRae from Sydney to the House.
The honourable member from Halifax Citadel? No. Oh, sorry. Cape
Heaven
Breton South.
forbid.
On a point of order.
As a Cape Bretoner, I would say, well, been called worse, I guess. Anyway, I just want to echo the comments of my friend from Cape Breton North, that of the visitor in the gallery today, and remind members of the House that when you see those Subway commercials that are on television, that man is responsible for them. And I can tell you that some days in this House, we've had Subway.
I don't think that definitely wasn't a point of order. Anyway, back to the honourable member from Hants East.
Thank you, Madam Speaker. I too, that'll make it all three parties, want to welcome the gentleman in the gallery, and I can confirm for the member for Cape Breton South, he has been called worse. So, Mr. Speaker, there is more that we can do for injured workers. I look forward to seeing this process continue as this bill moves forward. I definitely hope that the government members will ensure that if there's at all the possibility of not just incorporating the letter of the law, but incorporating the intent of the decision, that those with chronic pain are taken care of in the same way that others are. I certainly want to be sure that they're taken care of well by this government. There are others have been compensated by workers' comp. I don't think they necessarily have been compensated fairly as well. So I would like the government to keep that in mind as we move through this process, and I look forward to listening to other speakers, Mr. Speaker. Thank you.
Thank you. The Honourable Government House Leader. Yeah.
Yeah, okay.
The Honourable Government House Leader on an unrelated matter.
I thank the two members for allowing me to move in, Mr. Speaker. With the unanimous consent of the House, I'd like to revert to the order of business, presenting reports of committees.
Is it agreed? Presenting reports of committees.
Mr. Speaker, on behalf of the Chairman of the Committee on Law Amendments, I'm directed to report that the committee has met and considered the following bill. Bill number 1, an act to amend the laws respecting automobile insurance. The committee recommends this bill to the favourable consideration of the House with certain amendments.
Order this bill be referred to the Committee of the whole House on Bills. Public bills for second reading. The Honourable Member.
Bill number 20.
Bill number 20. The Honourable Member for Cape Breton South.
Thank you very much, Mr. Speaker. Mr. Speaker, I'm pleased to rise today in my place and say a few words about Bill 20, bill that is now before the House. And I, too, like other speakers before me, want to congratulate those people out there who have been in the forefront in trying to achieve improvements for fellow citizens in this province that many would feel have been unjustly dealt with in the past. And I make reference to some of the people that I know personally that have been kept this fight up, both from my own area and from throughout Nova Scotia, some of whom are with us here today in the gallery. But what I heard from the NDP in this particular debate so far is talking about the past, what was in the past and what was not in the past, and what wrongs were out there in the past. And I'd rather spend my time dealing with what we can do to correct this, as a result of this bill, to make some improvements that will affect positively the lives of people in our province. And I believe Bill 20 is an important step towards achieving fairness for workers with chronic pain, but the question remains, does it go far enough? And Mr. Speaker, no, it doesn't go far enough. But it's a start. It's a start, I believe, in the right direction. The automatic response, Mr. Speaker, of the NDP is one of disappointment. You know, it's easy for the NDP to get up and be profoundly disappointed with everything that comes before this House because they've never been in government in Nova Scotia. So they have no track record, you know, to be judged on in the past number of years. What they do, Mr. Speaker, is play the people of this province for their own political ends at every single opportunity they can get. That's what they do. That's what they do. Fortunately, they, up to this point, have not been able to get enough people in Nova Scotia on their side to form government, and we certainly hope that that trend continues in the future. Because I would shudder to think what would happen to workers and everybody else in this province if we ever entrusted the financial dealings of this great Nova Scotia to the NDP in the future, because I can tell you, Mr. Speaker, that if that happens, not only will workers in this province suffer, but everybody else in the province will suffer under this government. And all you have to do, Mr. Speaker, is look at what happened in previous NDP governments when they were the friends of the labor, friends of the oppressed before they get into government, and then turned on them after they get in government. That's the legacy of the NDP. However, Mr. Speaker, that's enough about my friends to the right here. I just want to, well, to the right in the chamber and far, far to my left, you know. Our caucus, Mr. Speaker, is more concerned with trying to ensure the government is held accountable in this particular bill. We have more concerns that injured workers achieve fairness, regardless of whether we score political points or not. And I think that's an important point to raise, that we're here to discuss ways of making life better for our fellow citizens in this province, not for trying to score political points. And when it comes to chronic pain, Mr. Speaker, there's no excuse or need to play politics. It's self-evident. We have to deal with the issue of chronic pain in this province. And Bill 20 recognizes the need to deal with this particular part of the legislation that's problematic for people in our province. Unfortunately, the bill has come before this House, though, not because the government wanted it here, but it was forced upon them. And that we have to keep in mind as this bill makes its way through the House and on to law amendments and then back to the House for Committee of the Whole House. Supreme Court, Mr. Speaker, is telling them to do it. That's what's happening here, and that's why the bill is on the order paper. It's on the order paper because there's a 6-month timeline on this bill. If they had left the timeline open, we wouldn't be talking about this bill this fall. It would probably be talking about it next spring, and probably if the government saw a way out of the House next spring, they'd probably leave the bill on the order paper again. But that's not what's going to happen here because the Supreme Court has said differently. So let's make no mistake about why we're dealing with this bill here today. If chronic pain, Mr. Speaker, is to be treated like any other disease, then that process should begin and finish within a quicker time frame. Mr. Speaker, the government says it will allow the Workers' Compensation Appeals Tribunal to handle the chronic pain cases. And while WCAT may be the appropriate body, does it have enough resources to deal with the issue? I think not at this particular point in time. If justice delayed is justice denied, then the government should ensure that WCAT has the resources they need to achieve important fairness for injured workers. One of the great concerns, Mr. Speaker, is how will the board interpret chronic pain? Will a new definition be hoisted upon injured workers so that they are again denied the benefits they should receive? We have to be vigilant to ensure that doesn't happen, Mr. Speaker. The bill we have before us, Mr. Speaker, on the surface seems like a good bill. Where we run into a problem is that this bill could allow a broad interpretation by government or the WCB. The disappointing part of the bill is that it does not significantly move towards the full implementation, Mr. Speaker, of the Dorsey Report, something that my former colleague from Cape Breton Nova pounded in this House all last year about when is the government coming with recommendations of Dorsey. And all we had was one recommendation over that period of time. And that, to me, Mr. Speaker, was indicative of the fact that the government did not want to proceed with any haste on implementing some of the recommendations with Dorsey that could have the impact of have a better impact on the people that Dorsey would be involved with. There are good provisions like the indexation of benefits, but this bill falls far short of implementing the 55 recommendations to the Dorsey Report. I believe, Mr. Speaker, that at the rate the government is moving on Dorsey, that a lot of the people that will be concerned with the final resolve of that committee won't be around by the time the recommendations are all implemented at the pace the government is moving. But we do have before us here today a bill that this government and the three parties in this House are going to deal with. And we're going to deal with it, and hopefully we're going to come out of here with a bill that is going to ensure justice for those people in our province that have been waiting a long time to get it. And I think at this point, Mr. Speaker, in debate, it's important to get back to the essence or the purpose of the Workers' Compensation Board system. I get very alarmed, Mr. Speaker, when some believe that it's the employer who pays for workers' comp and the employer should call the shots. I believe there has to be a partnership there. I believe that all the stakeholders should be engaged in participating in this particular program. This attitude fails to recognize that workers have given up their right to seek redress in the courts. This saves business money, and it should save the workers from waiting for their benefits. Equally unfortunate, Mr. Speaker, is that the WCB system was neglected throughout the 1980s when the unfunded liability continued to grow to staggering heights. At the rate it was growing, soon all workers would obviously come up short on benefits. Measures were taken, and the government did put more money into the system in order to do that. But unfortunately, we have a situation where workers wind up paying for the incompetence of other governments and previous WCB boards. The Supreme Court decision, Mr. Speaker, is clear. Financial difficulties with the board should not be used as an excuse to deny workers benefits. In other words, their financial problems should not impact on justice for workers who deserve justice and who have not been getting it, in my opinion, and in the opinion of our party. We're committed to that. We're committed to justice for the workers who are going to be impacted by any improvements that we put through the House in this session. The concerns we have here is that perhaps small businesses have not been adequately canvassed on this particular issue. Sort of been left out there somewhere, wondering where this bill is going and how it's going to impact on them. Has there been an impact assessment of this change, and can it be tabled if there is any impact on the changes, so Nova Scotians and workers will know what impact is there, and whether or not that impact is going to figure in the final resolution of this bill, and hopefully, as a result of that, workers will not be denied again because of circumstances that are beyond their control and perhaps they have nothing whatsoever to do with. In other words, they didn't create the problem, so why should they be denied benefits to deal with the problem? Another concern we have, and that's shared by the NDP, is that we haven't seen regulations with this bill as yet. And we'd like to see some regulations. I'm sure that the injured workers, other stakeholders in this province would like to see the draft regulations and ultimately the final version of that. Mr. Speaker, there was a time when politicians in this province could instruct the board when or when not to award compensation. Basing decisions on political expediency, I guess, in this province has not been a good deal for workers. But correcting this by positive legislation will be a good deal for the workers if the parties in this House are determined to make this bill as good as they possibly can for the benefits of the workers. I believe that we can achieve that. I believe that as we move this bill over to law amendments at some point, and hopefully we can do that fairly soon, so we can have some indication of the kind of representation that's going to come before the Law Amendments Committee with some ideas perhaps to make this bill before us a little bit better. And I think that all three parties have a responsibility here to do whatever we can to make the bill as good as we can, given the fact that in light of the Supreme Court decision, and also given the fact that we do have some implications of the Dorsey report that we still have to deal with. I'm not going to belabor this issue today, Mr. Speaker. I just wanted to say a few words in support of the bill. Our party is going to look for some improvements in this bill, but we're going to do that based on the information we receive from the stakeholders who are concerned about it, and also what we see and hear in the law amendments process. Our party is committed to, number one, we're committed to the decision of the Supreme Court, and we're committed to seeing that decision carried forth. But we're also committed, wherever possible, to ensure that we keep reminding the government that we have to get on with implementation of the Dorsey report and some of the recommendations that aren't necessarily connected with this bill. I believe that there is some room for some improvement here, and maybe some of the Dorsey recommendations that are closely associated or closely connected with this particular bill could perhaps find its way into this bill by amendment. That's a possibility. But I think we have to talk to the government about that. We have to talk to the opposition about that. And we have to listen to some of the suggestions that come before law amendments. So, Mr. Speaker, having said that, I'll take my place, and I just wanted to say that there does need to be a change here. There does need to be a recognition that there's justice that has to prevail here. Justice for the injured workers of this province who I think have been denied justice far too long. Thank you very much, Mr. Speaker.
The honourable member for Halifax, Shabakdal.
Mr. Speaker, if it were not for the fact that the Supreme Court of Canada issued its decision the other day in the Martin and Lasser case, this bill, Bill 20, would clearly not be in front of this House. What the bill does is it attempts to respond to the ruling of the Supreme Court of Canada in the Martin case, and it also adds in some response to the recommendations of the Dorsey report. But you know, the Dorsey report came out in March of 2002. That's a year and a half ago. That's a long time to go without a coherent legislative response to what it was that James Dorsey and his committee had to say in their very thorough report. Not that I wish to be understood as suggesting that Bill 20 is a thoroughgoing response to the Dorsey report. It is certainly not that. It is very much a slapdash response to the Dorsey report. But it's easy to conclude that if it were not for the occasion to bring forward some legislation having to do with workers' compensation that was driven, forced upon this government by the Supreme Court of Canada decision in the Martin case, there would be no legislation before us at all dealing with the recommendations of the Dorsey report or with any other aspect of workers' compensation. That's interesting, Mr. Speaker, because if you look at the three main pieces of legislation that are in front of this House this autumn, as introduced by the government, they weren't interested in bringing forward any of them. Bill 20, the one we're dealing with now, was forced upon the government by the decision of the Supreme Court of Canada. Bill 1, dealing with automobile insurance, was driven by us. And indeed, it's to be remembered that the government's preferred position is a non-legislated position. That was their official response to the rising crisis in automobile insurance. Let's talk with the insurance companies. No legislation is necessary. And Bill 2 on Sunday shopping, was really something I think that we can say was prompted by the third party. So contemplate that situation for a moment. The three main bills that are taking the time and attention of this House are all bills that weren't of interest to the government. If it weren't for external circumstances driving the agenda, there would be no agenda. There certainly wouldn't be Bill 1, Bill 2, or Bill 20. They wouldn't be tackling any of those topics. Bill 2 is just like Bill 1 in terms of the government. The topic, according to the Minister of Justice not so long ago, is completely off the table until 2005. Turned out not to quite be the case. Auto insurance, the government prefers a non-legislative solution. Workers' compensation, the government wouldn't do a thing if it weren't for the decision of the Supreme Court of Canada. You know, I think there is a bit of a lesson here in terms of style of government and in terms of what it is that governments hope to accomplish. The government, the present minority government, does not have a style and an approach to government that is the style and approach to government that we would take. In fact, I have reached the conclusion that for this party, now in government as a minority government, it probably doesn't matter to them, except in terms of minor inconvenience, that they are a minority government. They probably don't care. And you know why they don't care? It's because for them, being a government is not about bringing forward a legislative agenda full of positive changes for the people of Nova Scotia. For them, being the government means a clutch of them can be cabinet ministers. It means they can appoint people to agencies, boards, and commissions, and it means they can let contracts. You don't have to be a majority government to do any of those things. So they probably don't care. If it were not for externally driven factors like the Supreme Court of Canada decision, or for the issues that the two opposition parties have taken hold of and made their own and brought forward in a comprehensive way, the three centerpieces, the three most important of the items that are on the legislative agenda this fall from that government wouldn't be there at all. We would be faced with housekeeping items. We would be faced with minor items. We would be faced with another attempt, I'm sure, at beating the record for the shortest autumn session that there's ever been. That's a set of circumstances worth contemplating. And I think the public doesn't fail to note it. Well, Bill 20. Bill 20 attempts to deal with two aspects of workers' compensation. The first, as I said, is to respond to the Supreme Court of Canada decision in the Martin case. The other is to include some measure of response to what it is that was said in the Dorsey report. I want to deal first with the Supreme Court of Canada decision and how Bill 20 relates to it. And then if time allows, I want to deal with the Dorsey report and how Bill 20 attempts to deal with it. So let's deal first with the question of the Supreme Court of Canada decision in the Martin case. It's fascinating reading. Mr. Speaker, I think it might have been perhaps 3 or 4 years ago that in this very chamber I offered to the then Minister of Justice and Attorney General of the province a deal. I offered to cease giving lectures on constitutional law if he would cease bringing in bills that were unconstitutional. But you know what? It's never been taken up. The government has not really taken me up on this offer. So I look forward to exploring with the members of this House, yet again, some of the interesting features of Canadian constitutional law. In this case, particularly the Charter of Rights and Freedoms and its Section 15. Now, I enjoyed reading the decision of the Supreme Court of Canada in the Martin and Lasure decisions. And just to cut to the nub of what it is that the Supreme Court of Canada said, let's remind ourselves. The first thing the court said is that this particular administrative tribunal, the Workers' Compensation Appeal Tribunal, has the power to interpret and apply the Charter of Rights and Freedoms. Indeed, it has the duty to interpret and apply the Charter of Rights and Freedoms when it is dealing with any matter that comes before it. That was a reversal of the position that was taken by the Nova Scotia Court of Appeal when the case had come before it earlier on. I will have something to say about those decisions of the Nova Scotia Court of Appeal in a moment. But the second thing that the Supreme Court of Canada said in the Martin and Lasure decisions is that the Nova Scotia Court of Appeal got it wrong when it came to interpreting how the Charter of Rights and its Section 15 applies to the Workers' Compensation Act and its relevant regulations having to do with chronic pain. They said the Nova Scotia Court of Appeal got it wrong because they failed to find that there had been a violation of the rights of the individuals that were guaranteed by that section of the Charter. In other words, the Court of Appeal misread the implications of Section 15 of the Charter. They misread the implications of Section 15 in addition to misunderstanding the scope of authority that had been granted by the legislature to the Workers' Compensation Appeal Tribunal to interpret and apply the law that came in front of it. So there were two errors of the Court of Appeal of Nova Scotia that were reversed by the Supreme Court of Canada. Mr. Speaker, I've heard some reference in the debate by earlier speakers to the Supreme Court of Canada reversing itself on an earlier decision. And it's been suggested to us that we could not have predicted the decision in the Martin and Lasser cases because of the earlier decision. I don't think that's quite right. To the extent that the Supreme Court of Canada in these cases overruled or altered an earlier decision, it only had to do with a particular instance of how it decided whether a particular administrative tribunal had the authority to apply the Charter of Rights. That case was the 1996 Cooper case, and it had to do with the Federal Human Rights Commission. It had nothing to do with workers' compensation. And furthermore, although prior to Martin and Lasser, I believe it is correct that the Supreme Court of Canada had dealt last with the question of what administrative tribunals do have the authority to deal with the Charter. That is, had dealt last in the Cooper case. The Cooper case was preceded by several other cases, starting in 1991 with Cuddy Chicks Limited. There were several other cases, Weber versus Ontario Hydro, Tatro, Gaudry versus the Canada Employment and Immigration Commission, and of course the Douglas Kwantlen Faculty Association versus Douglas College. All of those cases set out the principles according to which courts should analyze and administrative tribunals should analyze whether they have the authority to deal with the Charter at all. So I say that although the Supreme Court of Canada overruled the Cooper case and essentially found that it had been decided incorrectly with respect to the Federal Human Rights Commission, it was, I think, abundantly clear what the principles were that were relevant and applicable when attempting to decide whether a body has been conferred the authority to deal with legal questions, and therefore, that is, an administrative tribunal has been conferred the authority to deal with legal questions and therefore has the power to apply the Charter. The central matter on this has always been the intention of the legislature. And the intention of the legislature, the courts have said, the Supreme Court said as early as 1991, may be express or it may be implied. But where the language of the statute says that the body in question may determine questions of law that come before it, then it seems pretty clear that that means they are not only empowered but required to interpret and apply the Charter. So I say that the decision on that part of the case in Martin and Lasser was no surprise. And I say that probably our Court of Appeal should have known that. The issue will have real implications, as others have noted, for all kinds of other bodies. One of them, for example, is the Nova Scotia Utility and Review Board. The Nova Scotia Utility and Review Board has, on its own, reached the conclusion that it has the power to interpret and apply the Charter of Rights. That has not been challenged in court. That was a decision of the Nova Scotia Utility and Review Board in the Peninsula South case from a year or two ago. And although that case was appealed, it was not appealed on that point. So it now seems clear, given the decision in Martin and LeSueur, that various administrative tribunals in the province of Nova Scotia, like the Utility and Review Board, will have that power. It seems beyond question that that tribunal, the Utility and Review Board, which is really the premier administrative tribunal in Nova Scotia, along with the Labour Relations Board, will be seen to have that power. Well, it's an interesting point, and I mention it not because it's directly related to the question of workers' compensation, but because if the government is looking for useful bills that it might bring forward, this is one that it might want to clarify. It might want to clarify the Constitutional Questions Act to make it abundantly clear that it supports and recognizes the powers of a range of tribunals to interpret and apply the Charter. So if they're looking for a useful piece of legislation, they might think of it as housekeeping. That would be one. Well, let's turn to another question. Let's turn to one aspect of what it is that the Supreme Court of Canada did in the case in Martin and LeSueur, and whether Bill 20 actually responds to this in any useful way. It will be recalled that at the end of the case, the Supreme Court of Canada suspended the application of its decision for 6 months. There's a 6-month delay. Now, why is that? The court looked at the situation, and they said that, of course, the delay in implementation of its decision, which, in essence, struck down as invalid a section of the Workers' Compensation Act and the functional restoration program regulations made under that. They said that a delay in that was appropriate because they were looking for ways to protect the workers. They weren't looking to do the government any favor. The Supreme Court of Canada was looking for a way to best protect the workers. And what they said was, this 6-month delay does not apply, of course, to Martin and LeSueur. Their cases would be decided according to the law as stated by the Supreme Court of Canada in its decisions. But they said, if we are going to strike down this section of the Act and the FRP regulations, then in effect, there's no coverage for people with chronic pain. There won't be anything. And they said, and I'd like to quote it. They said, quote, therefore, giving immediate effect to the declaration of invalidity of these provisions could result in prejudice to injured workers affected by chronic pain, as the board would then have no specific policies or provisions to rely on in such cases. while some default or residuary provisions of the Act and of the regulations, as well as policies of the Board, might apply, the results would likely be inconsistent given the considerable discretion which would be left to the Board in chronic pain cases. The default rules might even prevent certain chronic pain sufferers from receiving any benefits, as was the case for Ms. Lasseur. End of quote. Note that this is not the kind of delay that the Supreme Court of Canada put into place in previous cases, as, for example, in the Marshall decision, which was designed in order to allow the government some time to decide what it was going to do and perhaps to promote some kind of orderly transition to a new system. The thrust of what the Supreme Court of Canada is saying in Martin and Lasseur at this point in its judgment, at the very end of its judgment, is that it was worried about the position of people who are suffering from chronic pain. Because, of course, as you will see when you read the decision, the Supreme Court unhesitatingly accepts that this is a real condition with real consequences. And furthermore, what they say is that people with that medical condition cannot be discriminated against. That's the point about Section 15 of the Charter. That's how Martin and Lasseur won. So the court, in asking for the 6-month delay or putting in place the 6-month delay in implementation of its ruling, was first and foremost concerned about the injured workers. They're telling us something. We should be first and foremost concerned about the injured workers. We should be first and foremost concerned about the position of those with chronic pain. And do you know what this legislation says? Do you know what Bill 20 says? It says that the new section comes into effect next April. Well, that's not much help. What they're saying is, oh, look, the Supreme Court of Canada has given us 6 months in which we can continue to process perhaps some of the old cases, or there might be old cases there that for which there's perhaps some wiggle room. Let's not put the new system in place until the last minute that we have to. Now, I hope that that is not the intention of the government. I hope the government is not saying to any person who might be in a similar position to Martin and Lasseur that they have to argue any more than they already should through the normal process of filing a claim, that they deserve the individual scrutiny that the Supreme Court of Canada says is required in order for them to be dealt with like every other claimant who comes before the board. And I would appreciate assurances from the minister, hearing assurances from the minister at some point, that that is not what is contemplated, that that will in no way be tolerated, and that it will be made abundantly clear inside the organization that that is not the right way to go. This question of delays in the taking effect of constitutional orders or decisions from the Supreme Court of Canada is a vexed one. Although the Supreme Court of Canada has, in a few cases, chosen to exercise that power, which I think for many of us was a new power since the time the court has started to interpret the Charter, it hasn't been used a lot, but it's been used a few times. It's now been subject to at least some early academic analysis. I heard recently a talk by Professor Margaret McCollum of the University of New Brunswick Law School that focused on this, particularly in the context of the Marshall decision. There are reasons to wonder when this is a particular when this is an appropriate remedy, she reminded us. Leaving that, though, I want to deal, Mr. Speaker, with what the court is telling us with respect to chronic pain and whether Bill 20 adequately responds to it. I pointed out a moment ago what I hoped was not going to be an attempt to generate a small loophole or wiggle room. I want to deal now with some other aspects that are of concern to me. Consider what it is that the court has said about Section 15 of the Charter and the workers' compensation system. They have said, in case anyone had any doubts about it, that Section 15 of the Charter, the equality section, is in full force and vigor when it comes to the workers' compensation system. They've said to us, in effect, that the whole of the workers' compensation system should probably be examined in order to see whether it is in full compliance with Section 15. Although the Martin and Lasser decision deals only with chronic pain, why would the government not immediately say to itself, is there any other way in which the Workers' Compensation Act and its regulations might be in violation of Section 15 of the Charter? Surely this would have been the ideal opportunity to examine the Act and the regulations as a whole and attempt to decide whether there were any provisions that might be problematic. Let's remember what Section 15 of the Charter says. It says that there are a number of prohibited grounds of discrimination. But it says that in terms of particular examples: age, sex, place of national origin, race, mental or physical disability. But those are examples. Those are specifics. There is a general prohibition of discrimination. The general prohibition of discrimination, the court has told us, has to be on what are called analogous grounds. That is to say, prohibited discrimination under Section 15 only amounts to prohibited discrimination when it is something like the enumerated grounds. It has to be linked to the enumerated grounds in some way or similar to them. That is to say, they have to be related to things that are perhaps personal characteristics, things that are hard to eradicate. It doesn't mean that every distinction that's made in law is automatically discrimination that violates the Charter. Well, what we should have done, what the government should have done, is it should have examined the whole of the Act and brought forward a package of changes that responded to the kind of scrutiny that was gone through in Martin and Lasser. But it hasn't done that. What Bill 20 has done is it has focused only on that one aspect, chronic pain, and has taken the most narrow of interpretations of what the case is all about. Now, Why hasn't the government started, for example, with Section 10 of the Act? I'm not talking about Section 10A, 10B. I'm talking about Section 10, subsection 6, subsection 7. Subsection 6 says, the board may, by regulation, exclude any type or class of personal injury or occupational disease from the operation of this part. And subsection 7 says, the board may, by regulation, include any type or class of personal injury or occupational disease on terms or conditions including rates, types, and durations of compensation other than those specified in this part that the board may prescribe. Those subsections clearly have the potential to get the board in trouble under Section 15 of the Charter, exactly the way the Functional Restoration Program regulations and Section 10B of the Act got in trouble in the Martin and Lasser case. Why wouldn't the government do something about that? Why wouldn't the government take this decision seriously and implement it in a thoroughgoing fashion? Should have done that. And what about the definition of spouse in that act? Will that definition pass constitutional scrutiny? What about the automatic assumption sections? Are they going to get the board in trouble at some point? What about provisions that deal with age? And there are some in the Act, and I believe also in the regulations. Are they going to get the board into trouble at some point? What about dependents? Is the definition broad enough? Is it too broad? Those kinds of questions should have been asked by the Minister of Labour. Those kinds of questions should have been asked by the Workers' Compensation Board itself. Those kinds of questions should have structured this legislation. And I don't say that the result in each of these cases is necessarily obvious. What I do say is that there is potential for future litigation along the lines, there is potential for future litigation along the lines of Martin and Lasser on virtually any one of those other aspects of the law as it still stands, even if we were to pass Bill 20. And although I put it in terms of the board getting into trouble, the issue in the end, to my mind, is not really whether the board gets in trouble. The issue is whether injured workers are being treated fairly. At its core, that's really the issue. And what the decision of the Supreme Court of Canada invites us to do is to scrutinize this legislation, scrutinize each of its regulations in sufficient detail through the constitutional lens, through the lens of Section 15 of the Charter. Bill 20, however, has not done that. Bill 20 takes only the very narrow point decided by the court and attempts to implement it. So I'm sorry to see that this is the way in which the government has chosen to engage with the Supreme Court of Canada. Legislation is a dialogue, a process of dialogue between this chamber and the courts. When the courts speak, we have to respond. We have to respond appropriately. And it's not good enough. It's not good enough for the injured workers, and it's not good enough for the taxpayers to continue to stand by and allow situations that will call out for future expensive litigation to exist if we can avoid them. The Charter is always relevant to any laws that we pass. When any law comes before us in this chamber, we have to ask ourselves, do we have constitutional authority to deal with this subject matter? And we have to ask ourselves, does this bill pass muster when we think of it in terms of the Charter of Rights and Freedoms? Clearly, it's time for that kind of scrutiny of the whole of the Workers' Compensation Act to take place. Bill 20 fails to do that. Well, let's turn now to the second part of what it is that this bill deals with. You'll recall, Mr. Speaker, that I said that this bill deals first with the decision of the Supreme Court of Canada in terms of chronic pain, and then it deals to a certain extent with what it is that the Dorsey report had to say. Well, to what extent has Bill 20 advanced the Dorsey report agenda? I think, unfortunately, the answer is not very far. We've had the Dorsey report for a year and a half. Now, I think it's worth recalling what it is that the government was trying to do when it first commissioned this report. And it's worth recalling that this was not a one-person commission. However eminent Mr. Dorsey is, he didn't do his work on his own. He chaired the commission. This was a commission that was made up of Jim Dorsey as chair, but he was accompanied in his work by representatives of labor and management. He was accompanied in his work by informed representatives of labor and management. And of course, this is typically how adjudication of disputes takes place in the labor context, and typically how discussions take place in the labor context. That is to say, groupings are put together in which representatives of labor and management, broadly speaking, come together with a recognized neutral chair and try to work out their differences. They try to engage with the problem. And that's how the Dorsey Commission was structured. And there were very good people on it. And Mr. Dorsey himself, let's be clear, is one of Canada's most eminent experts on workers' compensation. He has a long history of work as an arbitrator. He was vice chair of the Canada Labour Relations Board. He was chair of the British Columbia Workers' Compensation System. Now, I think there is no person in this House who doesn't have respect for the work of Mr. Dorsey. Perhaps some members aren't familiar with them, but anyone who's had the chance to deal with him, either on other occasions or during the course of the work of his study of our workers' compensation system, would have come to have great respect for him. I'm happy to say that I know him personally. We were classmates at law school. and I've followed his career with great interest. He was selected by the government to be the person to chair this commission because of his undoubted expertise in workers' compensation matters. And let's be clear, when the report is read, when the Dorsey report is read, it is not uniformly on the side of the workers. It does nothing out of line. It makes very sensible suggestions about our system. And it makes page after page of suggestions and recommendations about changes in our system. That's important to remember, that there are page after page of recommendations settled on by Mr. Dorsey and the other members of his commission. It was no mean task to arrive at unanimous consent and agreement on the workers' compensation system. This is notoriously a difficult system to work with. The questions are complicated. Big money problems are involved. It's a big bureaucracy. A lot of people are affected, and a lot of people are irritated by it. And because, as with any problem in labor relations, there are sides. There's the side of labor, broadly speaking. There's the side of employers, broadly speaking. And there's a public interest in terms of the funding of the system and the administration of the system. All of this has to be worked out. And all of this was successfully worked out through the Dorsey Commission, at least worked out in terms of setting forth for us a blueprint of how we could go forward and make the appropriate changes to the legislation, regulations, and practices of the workers' compensation system in Nova Scotia. It's to be recalled that in a number of areas that the Dorsey Commission engaged with, it saw no necessity for change. It's to be recalled that when they dealt with some aspects of the system, they thought they were working fine. No change is necessary, they said. Well, that's fine. Now we know. But at the same time, there was unanimous agreement that some things should change. But you know what? Bill 20 does not implement the Dorsey report. Bill 20 only deals with a couple of aspects of what it is that the report makes suggestions about. And I'm sorry to say that on some of the points, it doesn't deal with them in quite the correct way. Let's start with the question of who's covered by the workers' compensation system. Now, you will know, Mr. Speaker, that under the existing system, this is primarily a matter for the regulations. And I've heard other speakers call upon the government to give us their draft regulations that they propose under Bill 20. And I want to agree with that call and ask for it myself. Where are those draft regulations? It's true that the Supreme Court of Canada decision in Martin and Lasser is only a few weeks old. But the draft regulations to implement that portion of Bill 20 that deals with the Dorsey report should have been within the contemplation of the government for the last year and a half. Because the Dorsey report has been available in the hands of the government for more than a year and a half. So where are those regulations? Where are those draft regulations? I raised the issue of draft regulations particularly as linked to coverage, but of course it could be broader than that. On this question of coverage, however, what Dorsey tells us is that there should be nigh on universal coverage. That's what the report says. Now, if you look at what has been put in front of us in Bill 20 in terms of coverage, what it says is, oh yes, let's have nigh on universal coverage, but the regulations will decide who isn't included. Well, a clause like that gets you no farther ahead. A clause like that represents such a potential undercutting of the main thrust of the clause of the bill that it renders the main statement of the bill virtually worthless. On the one hand, the legislation says, let's cover everybody, and then it says, oh, and by the way, the cabinet can decide that nobody's covered, or just about nobody's covered. Now that's not a very useful way to go. So it's no wonder we want to see the draft regulations. But I have to say that even if we saw the draft regulations, the hard fact, of course, is that the cabinet could create further regulations anytime and expand the categories. And being a minority government doesn't mean that they don't have the power still to put in place regulations. It won't restrain them. If they have that power, if we grant them this power in this House, then they'll happily regulate away the main thrust of the Dorsey Report's recommendations. They may promise that they're not going to do it. They may even show us draft regulations that show very limited exceptions. But they could go beyond it any time with no legal impediment. That's not a very satisfactory state of affairs. And we heard from a former Minister of Labour that under his government, under a different party than the one now in power, they were thinking of extending this to bank employees. Well, it's an interesting thought. Don't know that there's much to credit the minister or the former minister or his former government for in that thought. But the point is that it was all being done behind closed doors in the regulatory process. I think it was news when the former minister said that today, that they were thinking of doing it. Don't suppose he'll get in trouble for breaching cabinet confidentiality if that's what it was at this late date. But it was news. I don't think anyone knew. The classic phrase, who knew that they were thinking of this? But why should that go on purely in a regulatory forum without consultation? It's particularly the case that where we have a minority government, which, just to remind the members opposite, means they don't have enough members to pass legislation unless they get the consent of some members on this side of the House, they ought to be thinking about sharing their regulations. And I think it ought to be more than passing thought. We should be seeing details. And there should be minimal reliance on regulation when it comes to this kind of question. Well, that's one part of Dorsey that's been engaged with in this bill, and not very satisfactorily. Not very satisfactorily at all. He had other recommendations, and here's one. What he said was, the benefits that people are paid do go up according to the Consumer Price Index. But they're limited right now to going up by 50% of the CPI. Now, just think for a moment what that means. What that means is that every year in which there's inflation, and just about every year there is some inflation, anyone who's in receipt of benefits under the workers' compensation scheme has their benefits eroded. They have their benefits eroded because as the cost of living goes up, as the cost of the market basket of goods, as the cost of going out and paying rent, paying a mortgage, putting food on the table, doing whatever else that we all have to do, goes up, their income from a system that is supposed to replace the income they lost due to a workplace accident or injury is less able to keep up. It's eroded every year. If there's not full indexation, then there's erosion of your ability to live. There's erosion of the ability of those injured workers, of all of those injured workers, to put food on the table, to take care of their families, to provide shelter. Now, what Dorsey said, unanimously, not on his own, what he said, along with his tripartite commission made up of labor and management representatives and himself as chair, as the expert, is that over time this should move to 100% of CPI. Well, who can disagree with that? Nobody did. But you know what? What does this bill do? What this bill does is it says, let's move from 50% indexation to 55%. Well, I guess they took very seriously those words over time. Let's not rush, they must have interpreted Mr. Dorsey and his commission to say. Let's not do this quickly. Maybe we'll do it in 5% increments. That's great. Do it over 10 years? They're going to do it once a year? How many years, how many times a year will this bill come forward, or some bill similar to it? Will there be a bill like this every year for the next 10 years that adds another 5%? What timetable is contemplated? Is it really going to be 10 years? Will it depend on something? Will it depend, perhaps, on how well the investments of the fund do? If it is tied to progress in reducing the unfunded liability of the workers' compensation system, how is it tied to that? If the investments go up 5% in terms of their return, will the workers get 5%? Or will the workers only get 2% or only 1% or only 1/2 of 1%? Is there a formula? Is there a glimmering of a formula? Well, we're not told. It's not there. There's no promise. There's no firm schedule. It isn't in the bill that it should be 100% of CPI phased in over 10 years or 5 years. It doesn't say that. And remember what this is. This is a guaranteed statutory erosion of the ability to live of injured workers. It's what in another part of the country is known as legislated poverty. In other words, it's the legislation that guarantees that people stay poor. That's what that section does. And I don't think that's what Jim Dorsey had in mind. I don't think that's what his commission had in mind. What they had in mind was moving to 100%. Now, I think that can only be characterized as an inadequate response to what it is that the Dorsey Commission said. Inadequate, and I would say offensive. Well, I said earlier that there were pages of Dorsey Commission recommendations. Reconstituting the Board of Directors was one. Don't think that's in Bill 20. Service quality measures is another. Don't think that's in Bill 20. Now, there are others, that is, other recommendations in the Dorsey Commission report. But I think I've given enough of the flavor of Bill 20 compared with what the Dorsey Commission really said for members and the public to realize that this bill does not do its job. Mr. Speaker, I've tried to deal with what I think are the two main aspects, the two purposes, the two subjects that are melded together in Bill 20. One is to respond to the Supreme Court of Canada ruling in the Martin and the Sir case having to do with chronic pain, and the other is to deal in some measure with the Dorsey report. My conclusion is that in neither case does Bill 20 adequately engage with the issues. And it's not as if workers' compensation is a strange subject to the members of this House. Most of us have dealt with workers' compensation issues before. We deal with them in our individual constituencies when injured workers come to talk with us about their cases and about their problems and about the inadequacies of the system that has been put in place and that has existed for a century and that continues to cause problems for them. So we deal with them one-on-one in our own constituencies. We've dealt with them in this House, that is, we've dealt with the system in this House on previous occasions within the last few years when legislative initiatives have come forward. And we've dealt with workers' compensation when a year and a half ago the Dorsey report came out. This is a big system that involves a lot of money and that involves a lot of bureaucracy and a lot of controversy and a lot of complicated questions. But in the end, the fundamental structure of that system is known to us and is familiar, and we can grapple with it in a way that does advance the interests of the workers of this province, of the injured workers of this province, without causing serious problems for the employers or for the balance sheet of the government. I'm sorry that Bill 20 simply misses the opportunity to do what would have been the right things when it was forced upon the attention of the government. This is very problematic legislation. It's problematic mostly because of what it fails to do. But it's problematic because of what it purports to do as well. I don't think there's much in Bill 20 that calls for a positive interpretation. If there are solid positives, I would like to hear them identified. But so far as I can see, Bill 20 succeeds only in setting the stage for further sorrow for individual hurt workers, injured workers, and setting the stage for further frustrations, for further legislation, and for further litigation. Thank you very much, Mr. Speaker.
Thank you. If I recognize Member Halifax Atlantic.
Yes.
Is there a Liberal speaking? No. Okay.
I don't believe so.
No.
Okay. Yeah.
Sorry.
Thank you, Mr. Speaker. I welcome the chance to speak to this bill. I won't speak to it at length, but I'm delighted that it has come forward. I wish it had come forward with a little bit more strength, but I really don't want to think that the Nova Scotia flag is regarded as a flag of convenience. And by looking at the treatment of workers and injured workers, some of the most vulnerable members of our society, it would, up to this point, have been entirely possible to regard it as such. I should say that many of the constituents I represent have run afoul, first of something which many of the constituents whom I represent have run afoul either of something in their workplace or, to add insult to injury, of the Workmen's Compensation Board itself. I could list numerous people who have not even come into the constituency office, but who are simply living with the scars of injury and ill-compensated damage to their lifestyles, unable to continue to work. Should I be talking? Okay. This is a complex issue, and I realize that it has been brought forward on a very strict timeline put forward by the Supreme Court of Canada, but I wish this bill were not so sketchy. Regulation is certainly procrastination, and I worry about what will be happening in the form of closet legislation. Which industries will not be covered? Mandatory coverage should be expanded, as we know, to almost all segments of industry in Nova Scotia. But that is not necessarily going to take place. It's important to consider, first of all, who it is who benefits from the workmen's compensation system. It's not only the employee, but also the employer. The employer is protected from wildcard lawsuits. The employer has security. And the employee has a certain degree of security as long as uninjured. But up to this point, that security has ended with injury. Coverage, which has been the Dorsey report recommended that coverage be extended to casual employees and also to owner workers. That, however, has not been adequately addressed, and the owner worker is in fact the person most likely to get hurt. I think I may have mentioned to you before, in the context of the hurricane in the past, the extreme anxiety of the fishermen for their vessels. Several of them have been injured in attempting to protect these. These are owner workers, and there is no protection for them. Casual employees as well, the painter who falls from a scaffold, or the young woman who works in a coffee shop and is scalded by hot coffee, are inadequately protected by this, or potentially inadequately protected by this legislation. And by the time we couple the apparent loss of the Occupational Health and Safety Association's educational mandate, or at least the fact that it has been cut adrift from the Department of Employment and Labour, then we will have a very dangerous situation looking at us. I'm grateful that the chronic pain difficulty has been addressed at this point. It seemed that in 1999, just as employer premiums were lowered, so were the apparent benefits, or the available benefits, by the specific denial of chronic pain as. Thank you very much. Appreciate
Halifax
that.
Atlantic has the floor.
Thank you. I'm sorry. I find it very difficult to concentrate with too many conversations. I know it's hard for everybody. Nova Scotians have paid the second highest premiums, but gotten the second lowest benefits as injured workers. This, too, is indicative of the flag of of convenience. And at the same time, as I say, that before 1999, non-Nova Scotian companies had a 6-month exemption for paying premiums for their employees. At the same time that exemption was removed, legislation denied that chronic pain could be a benefit. It's a strange coupling of those two events. It's a long timeline to phase in family employees, but it's important that we get that, and the small workplace, as I've mentioned, is the one in which people are often in the most danger. Occupational health and safety regulations are far more likely to be ignored in this context, if they're even known, and we must protect all of the people who are, in fact, working for the benefit of our society. Thank you. I give up.
Please, all member Timberley Prospect.
Yes, thank you, Mr. Speaker. I'm going to make a few comments on this piece of legislation at this time.
Thank you. All member Timberley Prospect.
Thank you, Mr. Speaker. Mr. Speaker, in the number of years that I've been in this House and the opportunities I've had to serve my constituents on various topics, none is really more gut-wrenching than dealing with injured workers. Because I can tell you, Mr. Speaker, and I can tell you some personal experiences, and of course, this is an example where I will not be using names because there's many people who are injured workers who are concerned about the fact that somebody at WCB is going to pay attention to the fact that if I'm mentioning a particular worker who lives even in a certain community, there is such a paranoia about the fact that Big Brother from WCB is watching. So the cases that I'm going to refer to are going to be of a rather personal nature. Mr. Speaker, I want to talk to you, first of all, about the opportunity that I had when I received a call late one evening from a constituent who was in his garage with a gun. He was an injured worker. In fact, he is still an injured worker. And that injured worker was informing me that he was going to take his life. When he placed that call to me that evening, I began to realize, I guess firsthand, up front and personally, the absolute frustration of some of these men and women who are caught up in this WCB quagmire. Mr. Speaker, it is through no fault of their own that these men and women have been injured. They are not criminals. But, Mr. Speaker, the system has in many cases treated them like criminals. So when you get a call from a constituent who I know personally and had worked with through some of these issues that he had been dealing with WCB, and he's in his garage with a gun threatening to do harm to himself, you begin to realize this is an important issue to Nova Scotians. Now, what happened that evening, Mr. Speaker, is between my constituent and myself. There was a long drive that night to his home, and a longer night as we sat and talked about the worries, troubles, and stress that he was facing, that his family was facing, that his neighbors were facing. Because, Mr. Speaker, we were all worried about this particular injured worker. Mr. Speaker, I want you to know, because of your previous background, you've dealt with situations like that, the one that I have just mentioned. Now, as an MLA and as a school principal, I didn't have any training to deal with such an issue. And I know that when I returned that next morning, my wife says to me, "How did it happen? What eventually happened?" And I said to my wife at that time, becoming an MLA in this province is more than just standing in the legislature and answering phone calls in your constituency office. As you well know, Mr. Speaker, when someone reaches the stage that they are thinking of doing harm to themselves, they're sending out messages. They're sending out messages to their neighbors, to their friends, to their children. And Mr. Speaker, that is an example, the extreme example, with no names used and no communities mentioned because of the particular circumstances involving that man. That man is still injured. He is still waiting. He is still concerned about the concerns of how he is being treated by workers' compensation. Now, Mr. Speaker, I've had the opportunity to appear at appeals. I've had the opportunity to go with constituents. And let me tell you, the first thing that always strikes me about WCB is all the doors are locked. I don't know whether you notice that when you go into the foyer. It's like, based on my previous experience in an earlier career, in some ways it's like coming into the main cell block at Dorchester Penitentiary, where I worked as a teacher and they let me out on the weekends, Mr. Speaker, okay? But let me tell you, all joking aside, when you go into that office building, the security reflects the fact that many of the people working there are very ill at ease when they are confronted with injured workers. Now, Mr. Speaker, I share the frustrations of my constituents, as you have heard in this place before. I've met them on the street. I've met them at the nomination meeting for the member for Pictou West, who of course successfully was elected. And I recall when we went to that meeting that night, and I recall the member from Cape Breton Centre and myself, when we got out of the vehicle at that community hall, there were the injured workers of Pictou County. They were waiting to lobby the New Democrats that were coming to the meeting for the nomination at that time of Charlie Parker, of course, who's now the MLA for Pictou West. And when that happened, you begin to see the pain in those people's eyes. You begin to hear the frustration in their voice because they have had enough. Now, I know that there are members present who have had those nasty confrontations. And I know there's members on all sides of this House who are aware of the emotions that are involved in such confrontations. But I want you to know, Mr. Speaker, that when a piece of legislation is brought into this House and it involves injured workers, I automatically and immediately begin to want to know what is this legislation all about, and will it allow some peace for these men and these women? And Mr. Speaker, this particular piece of legislation is a piece of legislation that is a reactive piece of legislation. Now, I know we shouldn't play the game of if, but what if the Supreme Court had never come down with that ruling? What if that hadn't happened? Would we be here with this legislation today? My learned friend from Halifax, Sherbucto, took us through the Dorsey report, took us through what has happened because of the decision that was forthcoming from the Supreme Court. That's the question that we have to ask ourselves. Would we be dealing with Bill 20? Would we be dealing with this piece of legislation if the Supreme Court hadn't come forward with that ruling? Well, I can tell you, Mr. Speaker, injured workers are paying close attention. Injured workers, they follow this issue and they will follow it to the end, to the successful end when they are treated with dignity and they receive the just awards and rewards which they deserve. Now, Mr. Speaker, I have a couple of other examples that I want to bring to your attention. And I know the first one is a rather dramatic one, but I had to get that out of the way first, Mr. Speaker, because that's the sort of issue that rings home when people understand the possible suicide of an injured worker because he feels so worthless and he cannot help his family. He cannot be the father to his children and provide for them as he wishes. Instead, he must continually go through the hoops and jumps and must respond to every kind of demand that comes from workers' compensation. But, Mr. Speaker, there are a couple of success stories, and I want to share one with you. I'm fortunate enough to represent, as you well know, Mr. Speaker, the fishing communities along our coast. And there was an accident that took place with a masonry company, a very credible masonry company, in one of the communities that I represent. And that worker that was injured that day, when he was rushed to the hospital and the family was informed, let me tell you, Mr. Speaker, the community rallied around that family. The community rallied around that family because they knew that that family and that particular man who had been injured at work needed their help, needed our help, Mr. Speaker. When I had that opportunity to visit that injured worker, to visit him in his hospital bed, to visit him in his home, and to see that he has faith someone will take care of him. He has been hurt at work through no fault of his own. He is not going to be left alone. He is going to be treated fairly. Over the next number of years, Mr. Speaker, not months, over the next number of years, that particular resident of that coastal community, and through the diligence of his wife and family, and yes, I will say through the diligence of his MLA, pursued relentlessly the fact that the system must work for a man who has been hurt at work through no fault of his own. Now, I can tell you, Mr. Speaker, when that settlement finally arrived, and when I received that phone call that afternoon, it made it all worthwhile. It made it all worthwhile because that man had finally had his issues addressed. But in the meantime, he had to go through a series of struggles, a series of meetings, a series of very, very negative appointments, in his opinion, that he and his wife, that he and his MLA, that we pursued day after day, week after week, appointment after appointment, because those people knew, Mr. Speaker, we weren't going to go away. We weren't going to go away on this very well-publicized, unfortunately, well-publicized accident that had happened here in the HRM. But it was a fight, and it was a battle, and it was something that we did together. And Mr. Speaker, you'll notice I don't mention the name because the battle goes on. The struggle continues. Because what will be the implications now with Bill 20? Now, Mr. Speaker, you're well aware of the fact that deep in my dark past, I had an athletic career. And I want you to know that one of the better athletes that I ever played sports against is an injured worker. He's an injured worker today. And when you're physically active and when you're doing things athletically, and then as the body wears down, you realize you no longer can do them, well, you accept that. That's just father time catching up with you. Or is it mother time catching up with me? But let me tell you, there's an injured worker that I used to play sports against whose shoulders have been operated on so many times because of his injuries as an automotive mechanic that he cannot take a ball and throw it for his dog. In his backyard, he has a lacrosse stick. He has a lacrosse stick that he puts the ball in, and if you know how lacrosse sticks work, Mr. Speaker, he can whip the ball down that huge, expansive piece of property that he's fortunate enough to own. And the dog, of course, and he can have a few great moments together. But when you see that lacrosse stick, I want you to know, Mr. Speaker, that injured worker is angry. He's angry because of the injury that he's had and because of the training that he had as a specialized mechanic. He's unable to even take his arms and put them over his shoulders. So he takes the lacrosse stick and plays ball with his dog. Mr. Speaker, that's the sort of injured workers case that causes many problems for Nova Scotians. Mr. Speaker, when you reach that level, when you want to make sure that your family and your community wants to know that I'm not sitting home and I'm not on whatever the term is these days, on pogey, because I'm an injured worker. These injured workers want to be treated with dignity, they want to be treated with respect, Mr. Speaker, and they want to feel that there is some faith in the system. And that particular injured worker that I just mentioned to you, he called me that day when he picked up the morning paper, and where he gleefully announced to me, "Look at this. The Supreme Court of Canada has finally said something that is correct about injured workers. The message is clear. The system is broke. The system is broken. Excuse me, Mr. Speaker. The system is broken, and now there's time to do something about it." But throughout the time that has elapsed, the frustration of these men and women, is absolutely incredible. Mr. Speaker, I had the opportunity to attend a meeting of injured workers. It was held in the Legion in Halifax, Atlantic. And as we well know, of course, as elected officials, we go to a lot of public meetings. We hear a lot of issues that are brought up. But I want you to know that on that particular evening, Mr. Speaker, when that meeting was over, it was an emotional time for me as an elected official. It was an emotional time because you could sense at that meeting, at that Legion, out in Spryfield, the absolute frustration, the absolute hatred, if I can use that word, Mr. Speaker, of the process that these men and women have been put through. So here we are at Bill 20. Here we are at Bill 20, and here we are again on this emotional topic of injured workers. Now, Mr. Speaker, law amendments is a process that we treasure in this province. Law amendments and Bill 20 again, we will have the opportunity, the committee members will have the opportunity to listen to injured workers and the organizations as they come forward on this piece of legislation. And I was talking earlier to the new member from Halifax Clayton Park. The member from Halifax Clayton Park is a member of Law Amendments, and I must compliment her on the fact that she's dutiful, that she's hardworking, that she's attentive to the details of law amendments, and as she says to me, it is one steep learning curve. But I don't think that I can stand in the House today and speak on this particular piece of legislation. Understood. If she, when her previous career is municipal politics, I guess it is a career, if she in her municipal politics past has never had to do with injured workers, I've said to that new MLA, well, wait till law amendments. Wait till you have the opportunity to meet some of these injured workers and feel, not hear, feel some of the passion that will be delivered. And I look forward to that process, and I'm sure that the member from Halifax Clayton Park, when the time comes, as she asks questions of these injured workers, she will begin to sense some of the frustrations of the men and women that will appear in front of them. That process, Mr. Speaker, and you've heard members of our, you've heard members of our caucus bring on this topic, bring these items up before. You know, I always have measuring sticks in this particular business, Mr. Speaker. I remember when you and I were rookie members, and I looked at the fact of how tentative I was, and maybe you never were, but I recall that piece of legislation involving that controversial legislation, including that open pit in Spring Hill. But today I heard a working man speak in this legislature that I can take the time to pay attention to. And that's the new member from Cape Breton Nova. The member from Cape Breton Nova stands in his place and speaks again on an issue that he knows of what he speaks. He stands in his place and speaks on behalf of the people in his constituency, but he also speaks because of his own personal experience. And let me tell you, that's the measuring stick that new members should be looking at. You know, when I first came to this House, I used to compare myself to, heaven forbid, I have to admit it, John Leaf. John Leaf, the history teacher. John Leaf, the legendary mayor of Queens. But let me tell you, it wasn't that I was comparing myself to John Leaf or to George Moody or, of course, to John Holme. What you must do as new members is see how you've grown in the short time you've been here. The member from Halifax Clayton Park is going to grow, let me tell you. When she attends law amendments and hears these injured workers, and I encourage Mary Lloyd, and I know Mary Lloyd will be there to make that presentation that she always does. Undoubtedly, she'll be there. That will be a learning experience for the member from Halifax Clayton Park. But it's also a learning experience for the member from Cape Breton Nova. So we will stand in our place, each of us. Each of us will continue to speak for injured workers, no matter of what length of time, no matter we're speaking of some of the legal points that my friend from Halifax, Shabukto, brings up, or when I hear the past steel worker, and of course, who ran the Boys and Girls Club in Whitney Pier for years, when I have the time in this place for a new member to speak on such topics, that is time well spent, because that member is speaking on issues that are important to him, important to his constituents, and important to injured workers. Now, Mr. Speaker, I want you to know that we all deal with a lot of different issues. A lot of different issues. But I can tell you that in a previous career as a school principal, I dealt with a young boy and girl whose father was an injured worker.
Order, please. Would the honourable member like to move adjournment of debate?
Mr. Speaker, I will, and I will assure you I will be back on my feet at the next opportunity.
Motion to adjourn debate on bill number 20. Is it agreed? All those in favour say aye. Contrary-minded, nay. The motion is carried. I call upon the honourable member of Halifax Shabukto in regards to some documents that the honourable member referred to in his earlier debate that I've asked him to table copies of. The honourable member for Halifax Shabukto.
Thank you very much, Mr. Speaker. When I spoke at second reading on Bill 20, I quoted from the decision of the Supreme Court of Canada in the Martin and Lasser case. I quoted from paragraph 119. I failed at the time to table that, and I wish to do that now.
The order, please. The honourable member for Halifax Shabukto. I thought there was more than one document, wasn't there? That.
Thank you. No, I didn't quote from any other document. I refreshed my memory as to the name of a couple of cases. I've supplied Hansard with the names of those cases.
Thank you. The honourable member for Cape Breton South on tomorrow's hours and order of business.
Yes, thank you, Mr. Speaker. Tomorrow the House will sit from 2 to 6, and because it's our opposition day, we'll be calling resolution number 289 and resolution number 489. I would ask now that the House adjourn until 2 o'clock tomorrow.
Motion is the House adjourned to 2 p.m. tomorrow. Is it agreed? All those in favour say aye. Contrary-minded, nay. Motion is carried. The House is adjourned to 2 p.m. tomorrow.